Good evening, Chief Justice
You've
and
been, yes,
members of the Commission.
yes. You've been a judge of the High Court since 2007, isn't it?
That's right, Chief Justice.
And all in all, for how long have you acted at the Supreme Court of Appeal?
Chief Justice, it was for 6 terms over 3 years.
Yes. And you were here before
Yes, I've been here
for
twice
a
before.
vacancy for a vacancy in the Supreme Court of Appeal.
Yes.
Would you just want to tell us in your own words why it should be you?
Chief Justice, during the time that I've acted in the Supreme Court of Appeal, I've really felt that I fit into the system there. I enjoyed the work a lot. I enjoyed the collegiality a lot. And I do think that I can contribute a lot when being there. So those are the, in essence, why I would like to be there.
Thank you. President Bati?
Thank you, Chief Justice. Good evening.
Good evening,
Judge
President Mpati.
The last time that you acted in the SCA, what were the circumstances of you being invited again?
I beg your pardon.
What were the circumstances under which you were invited? You were invited quite late, weren't you?
I was invited overnight and quite late by yourself, President Mpati. And, but yes, no, I coped and it was a great term.
What had happened? Well, I mean, why were you approached late at night? What had happened in the SCA that required you to quickly come?
President Mpati, my recollection is that overnight one of the judges of the SCA was called to act in the Constitutional Court, and overnight you needed to fill that vacancy. And I collected the files from my colleague who went to the Constitutional Court. Yes, and I prepared them and for the next term, yes.
Oh yes, now I remember. Yes, indeed. And your stint at the SCA on that occasion, did you enjoy it?
Yes, I enjoyed it thoroughly. It was a very busy term. I think I wrote 3 or 4 judgments for that term, but I enjoyed it. I enjoyed every single term in the SCA a lot.
I think last time you were here, I asked you quite a number of questions, and I think I got the answers that I wanted from you.
I recall, so yes.
Yes, so I don't really have any further questions to ask you. I'll take names from the commissioners, and the first one is Commissioner Malema.
Thank you very much, President. I'm going to ask a different question. I can hear some people are already troubled.
Not on a point of order this time, Mr. Malema.
No, I just want to ask about the court environment. Is the court environment aiming at intimidating people? Like, it is so scary when you enter court. Is that the whole intention?
Commissioner Malema, I don't believe that that is the intention. And also it depends very much on different personalities being on the bench. You get people who are loud and you get people who are more soft-spoken, but I don't think there's an intention to intimidate anyone.
Don't you think the intention of making people feel intimidated, it sounds more like an apartheid style, like more than anything.
I I think it depends on personalities, and I think that's across the border. I think you get, but I do not think that there's any intention ever to intimidate or to revert back to any apartheid style way of doing things.
Do you think the SCA is friendly and more appealing to our people, or is it scary and intimidating?
You know, Mr. Malema, most in the SCA, mostly lawyers appear, advocates appear to argue matters on appeal. And lawyers are very much used to a certain level of debate with the judges. So I don't think it is scary at all for the public.
No, that's where you get it wrong, because the lawyer who appears before you is not his case. It's my case. And the way you are treating them when they appear before you, I feel like my case is not being heard.
That may be so in certain instances, but I can only speak for myself. And I like to treat all counsel with the utmost of respect, as I want to be treated myself.
What is your understanding of justice being served and being seen to be done? How do you understand it in a democratic environment?
Well, one of the aspects, most definitely, is the aspect, Mr. Malema, that you've just raised. And that is by treating people with respect, with dignity, and allowing people to raise their arguments, for all the issues to be properly ventilated, and when litigants walk out of court, for them to feel, I had my day in court. This judge listened to me, and I will be satisfied with this judge's decision. I know he's going to apply his mind to his judgment.
I'd like, at the center of everything else, we must, at the end of the whole thing, feel that we're listened to.
Absolutely.
But that is not the case with SCA. People appear before SCA and they are treated like, no, and before you know it, it's done. How are you going to contribute in changing that image of the, I don't like it. It sounds like an apartheid style.
Well, Mr.
So
Malema,
how are you going to contribute in changing the bullying picture of the SCA and give it a human face, a democratic face, wherein all of us, when we get out of it, we've got a sense that we're listened to?
Mr. Malema, my contribution will be as it was on the bench in the High Court. And as I've just said, I will listen to litigants. I will treat litigants with the utmost of respect. I will ventilate all the issues with litigants. And I will, as I've always done, keep on ensuring that people, when they walk out of that court, are satisfied that they had their day in court. I may mention to you that over my almost 9 years on the bench altogether, I've had very little or very few of my judgments being set aside on appeal. Only two, actually. One when I was an acting judge, and one on which there is academic controversy as to the correctness of my judgment as opposed to that one of the Supreme Court of Appeal. And I attribute, one of the reasons I attribute to that is the fact that I like to listen, I like to debate, I like to respect people, and I like people to respect me and to give people, because I'm a public functionary. I serve the public, and that is how I view my position in the High Court, and I will keep on viewing my position, if I'm appointed in the Supreme Court of Appeal, the same.
But you agree with me that a bit of transformation with regard to that type of an attitude in the SCA is needed?
But as I say, Mr. Malema, if there is such a perception and you raise it, and that is how you perceive it, and if there is such a perception, one that I was not aware of, but if there is such a perception, then it must be addressed, yes.
So you are not aware that there by the SCA is quick arrangement, and you must be out of that place very soon? You're not aware?
Mr. Malema, I've sat there in many cases. Really, I've sat there in many cases, and I've also sat where President Mpati was the president in a number of cases. And I don't know. We've debated the matters.
Now, let me ask the last question, which I said I was not going to ask. Can a court declare a person who acts inconsistent with the Constitution, who is in breach of the Constitution, not fit to hold office, including, amongst others, elected politicians? This person exists, has taken an oath, like judges, like members of the legislature, members of the executive, and then a court arrives at the conclusion that you have acted inconsistent with the Constitution, you didn't uphold and defend and protect the Constitution. And later on, there is an application that says this person, by virtue of having breached the oath of office, is not fit to, this judge, by virtue of having breached the oath of office, is not fit to hold office. Can a judge arrive at that
Mr.
determination?
Malema, you asked me a similar question just in a different format last year. And yes, of course, the High Court review administrative action. The High Court see that all action on review must be in accordance with the rule of law, with legality, with the principles of our Constitution. And yes, if a matter is taken to the High Court to review, then the High Court has that review function. It must determine whether or not conduct correspond to the tenets of our Constitution and the principles of our administrative law.
I didn't hear anything. I'm not a lawyer. I'm just a civilian. I'm asking you a simple question, and you must answer me like a civilian without legal background. If you're talking to Advocate in Zebeza, you can say those things. But with me, you have to simplify it. That's why
Yes.
I ask a simple question. Can a court, with the whole evidence presented before court, beyond any reasonable doubt, that this person who has taken an oath, has breached an oath, has not upheld the Constitution and protected the Constitution, and then the prayer before the court is that declare this individual unfit to hold an office? Can the court do that?
There are internal procedures. I'll try to explain it this way, Mr. Malema. There are always internal procedures before a court is approached. And the moment those internal procedures, except in certain exceptional circumstances, but as long as those internal procedures are being exhausted, then depending on the decision there, a court can be approached, and yes, the court will then determine whether or not that person ought to, because part of the office, of course, for most public figures, are to uphold the Constitution, certainly for us judges.
let me ask it differently. What happens to a judge who fails to uphold, defend, and respect the Constitution?
Then there will be an internal procedure, to call it an internal procedure. The Judicial Service Commission will investigate and come to a finding, and that finding will be submitted to Parliament, and eventually a court can be approached. But the internal procedures must be exhausted.
You said the report about the judge will be submitted to Parliament. Yeah, but he said Parliament. I want to get that clear. Are you saying we investigate a judge and we can submit a judge's report to Parliament?
No. Parliament can fire judges, to use that word. I think I can't remember the majority. I think it must be a 2/3 majority. I don't know what the majority is. But of course, the Judicial Service Commission will make recommendations.
Now, if the whole process is satisfied, then the Judicial Service Commission inquiry has come to a determination that indeed this judge has failed to hold, defend, and respect the Constitution. What happens?
The Judicial Service Commission will then make a recommendation to Parliament that this judge should be dismissed.
Thank you.
Thank you. Well, President Badi wants to put a question to you, but I just thought I must just clarify something much earlier asked, put to you by Commissioner Malema. You know, and I apologize to colleagues in advance because it takes a little bit longer than it's permissible. The judges of the Constitutional Court would simply descend on counsel at times before he or she had opened his mouth. Some would get so disorientated that they no longer know what argument they had come to present. Then we visited the European Court of Human Rights in Strasbourg and realized, or learned rather, that people are given a chance to present their argument uninterrupted, and at a particular point, only then are questions put to them. Rather than confuse them with questions, their clients are here, they are embarrassed, they look like they don't know, they are not even qualified to be legal representatives. I think that's part of the question. And of course, you might be aware that there are cases that deal with this flowing from, at least one flowing from the Supreme Court of Appeal, and I think that's what the Commissioner Malema had in place. Don't you think the judiciary, the courts must seriously think about allowing people an opportunity just to present their case first before they are interrupted? You find 5 or 3 judges at the same time asking questions. You no longer know which one to start with. You have even forgotten it. Do you understand what I'm talking about?
Yes, I understand.
Yes,
Chief
shouldn't
Justice.
people be allowed
Yeah.
to make their point, whichever way they choose to, without interruption, and only thereafter, whatever time you give them, and thereafter, you can put your questions to them, but still courteously. I think that's the essence of what he
Yes,
wanted to find out.
absolutely, and I agree with that. And I agree with, as I've mentioned, I like to give people the opportunity, because then they are satisfied at the end of the day that they had their day in court. This judge listened to them. And that's the approach I've always followed on the bench.
Now, his question was, if appointed, and to the extent that it might be a practice at times at the SCA that people are descended upon without being given the opportunity to articulate their position or their client's position, how are you going to contribute towards changing that environment?
Well, myself on the bench, by affording that party the opportunity to develop his argument, her argument, and by affording that party the opportunity of presenting the case fully. From my side, I will do that, and that is how I will contribute, and that will certainly wash over to other colleagues who follow a different approach.
President Badi?
I just have two aspects that I'd like to clear up with you. One, you are comfortable in Afrikaans. It might actually be your mother tongue, isn't it?
Afrikaans is my mother tongue.
And your experience in the SCA, are there still records that are in Afrikaans or parts thereof in Afrikaans?
Yes, every now and then there are still records in Afrikaans. And I've been on it on a few matters where the records were Afrikaans. And yes.
In fact, my experience is that it's not here and there.
No, it's not here in the
Indeed,
President.
in many, many cases,
Yes.
you will see that there are parts of the record that are
Absolutely.
in Afrikaans. And you would be comfortable with that kind of record.
Yes, and I think you've also put me on a few of those matters where, in fact, I can recall one where the record was only in Afrikaans. It was a murder committed by a 17-year-old. He killed his two parents. There the record was only in Afrikaans. And also there are, I recall a judgment which one of our colleagues wrote. He was the scribe, but there was a text from an Afrikaans textbook that was very relevant to the judgment in that case, and I did the translation of that text into English. The text was quoted in Afrikaans, and then I did a translation for purposes of the judgment, even though that wasn't my judgment.
Because mainly we write our judgments in English,
Yes.
even if the record is in Afrikaans
Yes.
sometimes. Right, let me go on to the other aspect of a perception or fact, maybe, that people are not, or counsel is not given a proper opportunity to present their case. Am I correct to say that with the heads of argument is filed something called a practice note?
Yes, absolutely.
And counsel in the practice note is required to indicate what the issues are in the case, in their appeal.
That's
Am I
right.
correct? Would there be anything wrong if counsel goes on something else that is out of the, is not an issue before court and be allowed to spend the whole day on matters that are not relevant?
President Mpati, of course, counsel must stick to the arguments and debate those arguments, because otherwise it may also result in the trial or the hearing not be fair to the other side, because the other side, the parties exchange practice notes and the heads of argument. So the one party, or the parties must know beforehand what the other party is going to raise in court as that party's argument and prepare on that basis. So if parties are allowed simply to argue anything that is not part of the practice notes and written heads of argument, then there is a danger that the other party is taken by surprise and wasn't prepared on that. And that, of course, expedite matters. And that also enable the courts to deal with the volume. And the Supreme Court of Appeal deals with a tremendous volume. That enables the Supreme Court of Appeal also to deal with that volume.
And have you been in cases where a judge would say to counsel, are you now stepping off the issue that you were busy with because I've got a question relating to that issue?
I beg your pardon, President?
Have you experienced cases or appeals where a judge of appeal would say to counsel, I note that you are now getting on to another issue. I've got questions to ask you on the issue that you were now
Certainly,
dealing with."
yes. No, but counsel have often, when in matters I sat on, counsel were taken back to an issue because there are 5 judges, and it may be that the matter was just debated between counsel and one judge, whereas the other judge also would like to debate aspects on that particular issue. So before council then steps off that issue, council is taken back to an issue. That often happens.
And would it be unfair for a judge to say, in case I forget this issue, can I ask it now? While counsel is arguing, is there anything wrong with that?
No, there's nothing wrong with that.
Thank you.
Commissioner Didiza?
Thank you very much, CJ. I was reflecting on one of your responses where you were asked about what you would regard as your most contribution to the law and the pursuit of justice in South Africa. In that response, you mentioned some of the role you have played on transformation initiatives within the judiciary. I just wanted to know from your acting stint in the SCA whether, in your own view, you think there are still transformation issues that needs to be dealt with?
Well, I think our country is long not finished with transformation, and it's an ongoing process. And transformation needs to be dealt with on all levels, and continuously so.
If I were to follow up, CJ, specifically in respect of the SCA, what would you say, in your own view, are some of those issues that needs to be dealt with? One of it that was referred to by the GCB was in respect of women's representation. When they were making
No, absolutely, and I think the gender correction should be made also in other courts. It is very difficult with a lifestyle for many women. I know that there are various reasons. The lifestyle is very difficult often for women to travel down to Bloemfontein and to leave their households for 6 weeks at a time. So there are various reasons, but yes, no, the gender issue is an issue that needs to be addressed.
Well, I'm not sure whether the lifestyle issue can only be confined
I'm not
to
yeah.
women specifically. I know you may not be saying so, but it's just unfortunate that that was the reference made. because
No, I'm not
I would
suggesting
dare
that.
say that even for men, that would be an issue. If the issue of the lifestyle in the movement is an issue of concern. But beyond the gender, I just wanted to hear from you. It might not be a long time, maybe, that you have served in the SCA, but I just wanted your own perspective on what would you say are the things that still require to change in that court for the better?
Well, I think one of the aspects was raised by the Chief Justice. Having looked internationally at other examples, and of course the transformation issue is an ongoing process, and you are seized, this body is seized, in considering that each and every time that you interview candidates and to see whether or not there is proper representation. Yes, those are including the gender issue. And the only point that I made, referring to the lifestyle issue, is that there must be a reason why there are fewer candidates applying for the SCA than for other courts. And the suggestion really is, my wife said to me, for one, that she'll never be able to leave our daughter for 6 weeks at a time. So I think that may be a reason, but I'm not suggesting for one moment that is the reason.
Well, on a lighter note, Judge Meyer, the Constitutional Court couldn't even attract 4, at least you are 6. Commissioner Nokesi?
Thank you, Chief Justice. On a lighter note, I observed that the length of judgments delivered by the SCA is very long. But I mean, by the Constitutional Court. But if you look on the judgments of the SC, it's very short, full of legal issues. What can you say about that?
Commissioner, I can once again, it's, some people are more long-winded than others. There is a saying, brevity lubricates the wheels of justice. I personally don't write 20, 30, well, easily more than 20 pages. I like judgments between 12 and 20 pages. That's my own style. But you've got people with different styles, and each one has his or her own style. Some are more long-winded than others, but I prefer. There are a few judgments that I wrote that were very lengthy. In the questionnaire, I mentioned one, a criminal matter of 239 pages. But it was a 27-week trial, 27 weeks, where each and every issue that could possibly be raised was raised, and I had to deal with all those issues. So that is extraordinary. But yes, I know that the Constitutional Court, with all due respect, judgments are much more lengthy than most of the judgments emanating from the Supreme Court of Appeal.
Yeah. Secondly, Judge, there has been a general say that the judiciary is under threat from other arms of the government. But when I read somewhere another document where I think it's Justice, his Deputy Chief Justice was writing there, it's saying that the biggest threat to the judiciary is the judiciary itself. Say if you don't deliver judgments on time, people will criticize. If judgments are written with wrong reasons, they will be criticized. What would you say on that? What is your comment on that?
No, absolutely. No, there's, and that is what the judiciary must do, and that is what the judiciary also, to a certain extent, does, is to look inside at themselves. And yes, it is simply not right for any judgment to be reserved for a year, for 2 years, for 3 years. You get that. And that is not wrong. One must dispense with justice as soon as practically possible. There are very busy divisions in this country, like the Pretoria division of the High Court, the Johannesburg division of the High Court, where judges are under tremendous pressure. But even so, there is no excuse for any judgment to be reserved for such a long period of time. And that happens. I'm aware of the fact. It happens.
Yeah. And then this brings me to the question of who got the cards. Who got the cards? Do you really believe that the mechanisms in place for judicial accountability are enough? Do we have enough mechanism of judicial mechanism for judicial control? I mean, accountability, I'm sorry.
Well, I think that the Judicial Service Commission, of course, is the body, and of course the Chief Justice, the office of the Chief Justice, and the mechanisms are now coming into place after the recent judgments, and there are still aspects of it probably that will further be debated. But yes, we need to have a firm system of channels and mechanism in order to call judges to account. And I think that is that is a process being implemented at the moment.
That's the last now.
You are asking the fourth now.
Oh, but thank you.
The Mail and Guardian article, and now what next? Commissioner Fourie?
Good evening, Judge Meyer.
Yes, Commissioner Fourie.
You've earlier referred to the removal of judges by Parliament. I'm just curious to hear your view. The procedure is that if a tribunal submits its report to the Judicial Service Commission, and the Judicial Service Commission, for example, finds that particular judge to be grossly incompetent. The matter is then referred to the Speaker of the National Assembly, and then the National Assembly may call for that judge to be removed by a resolution adopted with a supporting vote of at least 2/3 of its members. I just want to test you. If the judge...
Well, I'm glad that you know the facts on that. I've
Yeah.
never ever dealt
Yeah.
with, and I didn't foresee that question, but that is my recollection.
Fortunately, in our constitutional democracy, it has never happened.
Yes.
But I'm just thinking aloud, and I want to hear your views. If the JSC has gone through the whole process, finds a judge to be grossly incompetent, but Parliament does not, by a two-third majority, adopt a resolution to have the judge removed, does that mean that judge can continue to be a judge unhindered? And if so, what would that do to the image of the judiciary and that particular judge in particular?
But Commissioner, we've never had that situation, and that is the law as it is at the moment. And Parliament is also elected by the people of this country. And if a two-thirds majority of Parliament believes that judge is fit enough to be a judge, then that really is the wish of the country. But that is more a political issue than anything else, because that is the law as we have it. And the legislature deemed that to be appropriate. And we never had an example, unfortunately, of where there was a clash between the
Unfortunately or fortunately?
Fortunately,
Yes.
where there was a clash between the recommendation of the Judicial Service Commission and the decision eventually, or the vote eventually taken by Parliament. Also, the appointment of judges are being, the Judicial Service Commission renders its recommendations to the President of the country, and the President then appoints, and invariably the President appoints those being recommended by the Judicial Service Commission.
No, the Constitution says all judges except certain judges must
Yes, that's
be
the law.
appointed by
Yes.
the President on recommendation
yes.
of the JSC. So it's not a discretion that the President has.
Yes.
You say invariably.
Yeah, well.
Thank you, Chief Justice.
Thank you. But that's a very interesting legal question, isn't it? What, in your view, ought to happen in circumstances where the Judicial Conduct Tribunal has recommended that a judge be impeached, but there is no two-thirds majority? What should happen? Can a court of law be approached to take over from Parliament a constitutional responsibility that rests with Parliament? Can it do it? Is it constitutional?
Well, that's the responsibility in that instance lies with Parliament. Parliament must fulfill its constitutional responsibility.
Yes, my question is, if they are divided now,
And
there's no two-thirds, can a court of law be approached to say, hey, these people can't agree, take over? Does it fall within
I don't believe that
the powers of a court
that is a very
regard being had to separation of powers considerations?
but it's a very interesting question, and one can debate the issue.
That's why I'm asking
Yes,
you.
on a very, but I do not believe, as we, in terms of how that, then there will be a contravention of the separation of powers. Then the courts will fulfill the function of Parliament, because Parliament was given the authority to, on a two-thirds majority. So if a two-thirds majority cannot be achieved in Parliament, then to run to court and say, well, there was no two-thirds majority, there was only 60% of the votes went in favour of dismissing Judge X. So please, court, give us an order dismissing Judge X. Yeah, that's...
It can't happen.
No, it can't.
And so even if he has killed two or three people, he must go back and be a judge.
Yes, and politicians must be accountable to their electorate.
Yes. Thank you very much, Judge Meyer. You're excused.
Thank you, Chief Justice. Thank you, President Mpati, Deputy Minister. Commissioners.
Well, on a lighter note, as you go, I understand your colleagues as the SCA say our judgments are door stoppers. That's how big they are.
They are long to read, Chief Justice.